Audio கேக்குதா?
Yes, ma'am.
Okay. 1 minute. Okay, first of all, really sorry I was late for the class. Nothing because of nothing professional, personal reasons kaga I was just late. I'm really sorry for that. I'll make sure that it will not happen next class. Okay, next time. Now, coming to this ICI material, I got to know that many of you have not received books. Books oda delivery status enna daivu seidhu check pannunga. Maximum I want to give you notes. That is the reason why I started picking up notes and getting it ready for you. But then unfortunately I am not able to fetch the time to bring that notes for you. So I'll try wherever it is possible. I'll try to get notes. If not, we will follow the ICI material, and in the ICI material irundhu dhaan na ungalku notes me ready pandren. So I know exactly what to cut short and what not to, and we will go accordingly. Able to understand? If at all you are not having your textbook, எனக்கு ஸ்டார்டிங் ஆஃப் த பேட்ச்லையும் இதுதான் சொன்னாங்க, நிறைய பேருக்கு டெக்ஸ்ட் புக் வரல. அந்த ரீசன்னால தான் ஐ ஸ்டார்டட் கிவிங் யூ நோட்ஸ். பட் இன்னுமே உங்களுக்கு நோட்ஸ் டெக்ஸ்ட் புக் வரல அப்படின்னும் போது இட்ஸ் ஆல்ரெடி பாஸ்ட் 1 monthக்கு மேலே ஆகுது. So please have a check. Call ICI student helpline and please check what is the delivery status. Okay. That being said, let us continue with today's class. Now, today's class, let us start with the unit number 6. If possible, let us take in complete unit number 6 today. Very small chapter, important chapter. Contingent and quasi-contract. Contingent contract and quasi-contract. So, under this quasi-contracts, we already know what is a quasi-contract. It is not a contract actually, okay, but it is created by whom? Law. It is created by law. Okay. Now, just because it is created by law, should I follow it or not? I should definitely follow it. I am bound by such contract. Okay. Whether the contracting parties have known each other or not, they may or they may not also. Okay. So that is quasi contract. Here we will study how different kinds of quasi contracts can be seen in reality. Next comes contingent contract. We will take it one by one. Sir, what is a contingent contract abdina? It is a contract which is based on a contingency, Now, what do you mean by contingency? Contingency means it may happen or it may not happen. That kind of action is called as contingency. Now, based on this, if you are entering into a contract, then such kind of contracts are called as contingency contracts. Able to understand? This is not equal to wager. Wager is where you want to win or lose. Okay, va? And a contingency contract is something different. Let me give you an example. Okay. Say for example, I am entering into a contract to deliver you 1,000 cameras, okay, and all those are imported cameras. Now, I will enter into a contract based on a contingency. Enna abdina, sir, if I receive the camera from Japan, okay, only if I receive the camera from Japan on so and so date, I will be able to deliver or perform the contract on so and so date. Say for example, the contract is for say June 20th. Now, this contract is between Abhi and Dinesh. Abhi is ready to give camera to Dinesh for say rupees 5 lakhs. Okay. Now, Abhi is giving camera and Dinesh is paying 5 lakhs. But this contract is based on a contingency. What is that contingency? Contingency is June 18th kulla I should receive camera from Japan. Okay. So, based on this contingency, in the contingency vandu clear ana mattum da this contract can come into effect. If at all June 18th குள்ள கேமரா கிடைக்கல அப்படின்னா this contingency is not there. Therefore this contract will not be performed. Able to understand? Let us start reading now. Yes, start reading. A contract do or not to do something if some event collateral to such contract does or does not happen. Okay, now let us see with that same example, apply the same example. We are contracting to do or not to do. To do enna to do, to deliver camera. Okay, if some event was, what is that some event? Import from Japan. Okay, and this some event is collateral to that contract. Collateral means it is somewhere related to the contract. Okay, appo இப்போ இந்த import நடந்தா மட்டும்தான் I can deliver the cameras to Dinesh. அப்போ this import of cameras from Japan is collateral. It is assist. It works like a secondary action to the earlier contract. Now this collateral to such contract does happen or does not happen means only if I get from Japan I will be able to do the contract. If I don't get it from Japan I will not be able to do the contract. அப்படினா என்ன அர்த்தம்னா, in case of a contingency contract there's always a contingency on some collateral event which is directly related to the main contract. Only if the collateral event happens, the contract will be performed. If the collateral event does not happen, abdina, the activity, the original contract cannot be performed. Okay, let us read example number 1. Mr. A contracts to pay Mr. B 1 lakh if B's house is burnt. This is a contingent contract. Why? Because, sir, what is the contingency here? B's house is being burnt. So only if it is burnt, he will pay. If it is not burnt, abdina, he will not pay. Madam, why it cannot come under wagering contract? Because a house being burnt is within my hands, within my control most of the time. Okay, va? Appo something which is not in my control and something which I am not interested in can only come under wagering. But here, house, maybe most of the time it getting burnt is within my controlled activity, and house is something that I am personally interested inside. Able to understand? Ennoda veedu illaya, so definitely it cannot come under wagering. Wagering ki two important conditions enna, the activity should not be in my control, 100% it should not be in my control, and second activity I should not have any personal interest. Ana inga my personal interest is always there. That is why, that is the only reason the definition says it is collateral to such contract. It is collateral to contract. Collateral na something related to the contract. In case of wagering, this relationship will not be there. Able to understand? Next one, example number 2. Mr. A makes a contract with B to buy his house for 50 lakh rupees if he is able to secure a bank loan for that amount. This contract is a contingent contract. Now, what is the collateral event here? Getting a loan. Now, only if he gets the loan, he will be able to take the house. Appo loan kadaikalana, he cannot buy the house. Now, ஏன் இந்த மாதிரி contingency contract உள்ள எடுத்துட்டு வராங்க அப்படினா, don't you think it looks like a condition? Yes, the reason why they have put it is because they want to satisfy some event. So, because of that event, satisfaction of that event, I will be able to perform the contract. And the particular condition satisfy agla abdina, then there is no necessary to perform the contract. You cannot file any case against me for non-performance. Able to understand? Now, what is the collateral event? And the collateral event go, they have given you a definition. Let us go read. An event which is neither a performance directly promised, part of the contract, nor the whole consideration for a promise. So, in our example between Abhi and Dinesh, what was the contract, sir? What was the contract, sir? To deliver camera, correct? And in turn, what was the consideration, sir? What was the consideration? 5 lakh rupees, correct? Now, what was the collateral event for that? Sir, import should come from Japan. Japan on which date, sir? June 18th is the date, correct? Now, on satisfaction of this collateral event only, I can perform this contract. This collateral event is not the actual event, actual performance of the contract. This collateral event cannot be also the consideration to the contract. Able to understand? Then such an event is called as a collateral event. Able to understand? Now, they have explained the same example in the view of collateral event. Okay, let us start reading. A contracts to pay B 10 lakhs if B's house is burnt. This is a contingent contract. Here, burning of the house is neither the performance promised nor is the consideration obtained from B. The liability of A arises only on the happening of the collateral event. Okay. Go to example number 4. A agrees to transfer his property to B if her wife C dies. This is a contingent contract because the property can be transferred only when C dies. Now, C dying will happen or will not happen? Definitely it will happen, but we don't know when, isn't it? Whenever she dies, at that point of time, the particular property will be transferred. Able to understand? அப்போ அந்த collateral event அப்படின்றது எப்போ நடக்கும்னு எனக்கு தெரியாது. நடந்தது அப்படின்னா அந்த மொமெண்ட்ல I will perform the contract. Okay. It is similar to a condition where only if the condition satisfies, okay, then I will perform the contract. If the condition does not satisfy, I need not perform the contract, and automatically what happens? The contract gets discharged. Ma'am, say for example, A is living forever, 100 century தாண்டி ஓடிக்கிட்டு இருக்கு அப்படின்னு வச்சுக்கோங்க. In this point of time, A dies. Mr. A dies. What happens to the contract? Again, the contract goes void. Okay, wow. Next one, essentials of a unless and until, okay, A would a legal representative comes into picture and A has given assigned the rights to legal representative of A, then there is no requirement to perform the contract. Okay, yeah. Essentials of a contingent contract. What is the first essential? Essential na nama rules. Essential meaning enna? Rules of a contingent contract. First rule, the performance of a contingent contract would depend upon the happening or non-happening of some event or condition. So only if that event or condition is satisfied, I will go and perform. Next one, the event is referred to as collateral to the contract. Why it is collateral means somewhere it is related to the contract. Okay, totally unrelated item we cannot say it as a condition or a collateral event. It should be related to the contract. Let us go read. But what is the condition abdina? That event should not be part of the performance, or it should not be part of the consideration that is paid. Okay. Now, they have given 2 examples. Let us go read for us to understand better. Now, this chapter is very, very important. So, please keep that in mind and listen. First, Mr. A agrees to deliver 100 bags of wheat and Mr. B agrees to pay price only afterwards. This is a conditional contract and not a contingent. Reason enna, sir, contingent na enna sir? Contingency na enna? That is a different event which is related to original contract, correct? But when a person comes and says, I will pay the amount only after your delivery of goods abdina, is there any event as such outside the contract? Sir, actually, if a contract is between, say, Abhinay and Vidyut, okay, now this person is the seller and this person is the buyer. The seller has a promise to give 500 kgs and buyer has promised to pay say 50,000 rupees. Okay. Now buyer puts a condition enna appadina only on delivery I will pay 50,000 appadina, then think and say whether it is a collateral event. What is a collateral event? Event that is outside the contract. Okay. See, in here, is there any event that is outside the contract? No, it is not there. How do you say? Sir, இதுக்கு முன்னாடி there should be a condition that is separate from the contract. ஆனா இங்க condition என்ன? Go perform. What is the performance? Go deliver. Only then I will make the payment abdina. It is only a condition for making the consideration. Paying the consideration. There is no collateral event as such that is outside the contract. Okay. So for you to call a contract as contingent contract, a collateral event should be out of the contract. Out of means separate from the contract. Okay, and that collateral event should not be the performance of the contract nor the consideration of the contract. And inga kuduthirukka example la think and say the condition which he is saying to pay the price only afterwards, after receiving the delivery of goods now, then this condition which is there is part of the delivery of the contract, part of delivery. Enna delivery? Delivery of the goods, part of performance of the contract. Okay, and we already knew that collateral event cannot be the performance of the contract nor it can be the consideration for the contract. Everyone, have you understood this? People online, have you understood? So many people are sitting online today. Have you understood online, people? Okay, now going to the second example. Where Mr. A promises to pay 1 lakh rupees if he marries a C is not a contingent contract. Sir, Mr. A is promising to pay Mr. B 1 lakh rupees. If at all, he is marrying C. Now, how can you call this as a contingent contract? You cannot. Yeah, reason enna, there's no outside contract that is happening. Able to understand? Now, something outside should happen between or there should not be any involvement of B inside the contract. B should not be there. Something outside of it, there should be a contract. Only then it can be called as collateral. But what is the event that is here asked by this person is only a condition. In a condition, he is asking Mr. B to go marry Mr. C. Okay. Now, why it is not in the இன்னொரு reason சொல்றேன். A is ready to give 1 lakh for what purpose? For marriage. Now, marriage is with whom? Mr. C. Now, we already know a collateral event cannot be a consideration. Able to understand? Previous example, what was the example showing? He was giving a condition which is part of the performance itself. நீங்க டெலிவரி பண்ணாதான் நான் உங்களுக்கு கேஷ் கொடுப்பேன் அப்படின்னா then that condition is a part of the performance. Collateral event cannot be a part of performance. Second கொடுத்திருக்க example is also not a contingency. Reason, A 1 lakh ரூபாய் கொடுத்துட்டு in turn what he is asking is marrying C, and this is not a separate contract as such because marrying C falls under the consideration for this contract. Collateral event cannot be a consideration. Next one. Mr. A agreed to construct a swimming pool for B for 20 lakh rupees and B agreed to make the payment only on the completion of the swimming pool. This is again what? This is again what? Not a contingency. Reason enna? Think and see. Reason enna? Because it is part of the performance. Part of the performance. Understood? Good. Next one. Contingent event should not be a mere will of the promiser. அப்படின்னா என்ன அர்த்தம்னா, sir, say for example, previous example நான் எடுக்கிறேன், import from Japan. Okay, say for example ஜப்பான்ல இருந்து சென்ட் பண்ற கம்பெனி எனக்கு சென்ட் பண்ணுது இல்லையா, அந்த கம்பெனி என்னோட சப்சிடரி கம்பெனின்னு வச்சுக்கோங்க. நான் இங்க என்னோட ஹெட் ஆஃபீஸ் மெயின் கம்பெனி நான் இங்க இந்தியாவில் வச்சிருக்கேன். என்னோட சப்சிடரி கம்பெனி இஸ் இன் ஜப்பான். ஓகே, அண்ட் பிகாஸ் ஆஃப் த ஹைடெக் டெக்னாலஜி ஆல் ஆஃப் தட் I am planning to manufacture there using their know-how which is available in Japan, and after that import it to India abdina. Don't you think the control of that particular company is with me? I can control the company from here itself. Yes or no? அப்போ அந்த கம்பெனில இருந்து அந்த சேல்ஸ் ஆர்டரை அந்த சேல்ஸ் ஆர்டரை ஃபாலோ பண்ணி சேலை கன்வெர்ட் பண்ணிட்டு அதை டெலிவரி பண்ற வரைக்கும் எனக்கு அதுல கண்ட்ரோல் இருக்கு இல்லையா? அப்படின்னா you cannot treat it as a collateral event. Able to understand? Okay, which means on your will it may happen or may not happen. See, இங்க நீங்க வந்து அந்த கம்பெனில you are a 100%, say for example it is a 100% subsidiary. 100% subsidiary என்ன மேடம்? சார் 100% subsidiary means அந்த கம்பெனியோட எல்லா ஷேர்ஸும் யாரு ஓனர்? நீங்க தான் ஓனர், கரெக்டா? அப்போ indirectly or directly you can definitely control the entire company. Okay, அப்போ say for that event, okay, shipping the goods from Japan to India, on your nod of head it can happen or not happen. அப்படின்னா என்ன அர்த்தம்னா, நீங்க தலையை அசைச்சிங்கன்னா அவங்க அனுப்புவாங்க, நீங்க தலையை அசைக்கலன்னா அவங்க அனுப்ப மாட்டாங்க, கரெக்டா? அப்போ அதை பேஸ் பண்ணி நான் இங்க ஒரு கான்ட்ராக்ட் போட்டேன்னா அது கரெக்டா தப்பா? தப்பு. That is what they are trying to say. It should not be your mere will அப்படின்னு சொல்றாங்க. Okay, when you say it is a collateral event, it is having a contingency inside it. Na contingency na enna? It may happen or may not happen, என்னோட கையில இல்ல. Okay, ஆனா ஒருவேளை அது என்னோட 100% சப்சிடரியா இருக்கும் பட்சத்துல நான் என்ன சொல்றேனோ அதை ஆட்டோமேட்டிக்கா அவங்க ஃபாலோ பண்ணுவாங்க. நான் அனுப்புன்னு சொன்னா அனுப்புவாங்க, நான் அனுப்பாதேன்னு சொன்னா அனுப்ப மாட்டாங்க. அப்போ ஆப்வியஸ்லி என்னோட வில் என்னமோ அதை நான் அவங்க மேல யூஸ் பண்ண முடியும் இல்லையா? isn't it? Yes or no? Correct. அப்படி இருக்கும் பட்சத்து based on that if I'm doing a contract there's no contingency at all. Okay, that is the reason they have given this as a point. Contingent event should not be a mere will of the promisor. Let us read. The event should be contingent in addition to being the will of the promisor. Let us read example number 6. Pay 1 lakh if he chooses so. If he chooses so means if I want I will pay, if I don't want I will not pay. Can you call that as a contingent event? No, you cannot call it as a contingent event. However, where the event is within the promisor's will but not merely his will, may be contingent event. Now what are they trying to say, sir? Sir, for example, if I go to Mumbai, I will be able to sell the house. If I go to Mumbai, I will be able to sell the house in Mumbai to you. This is what I want to give it as a example. Now going to Mumbai is in my hands or not? It's in my hand, isn't it? Now how can you call it as a contingent event? Okay, புரியுதா நான் சொல்றதுமா? ஆன்லைன் புரியுதா? No, it is not certain. நான் நினைச்சா மும்பைக்கு ட்ரெயின் பிடிச்சி போனேன்னா கான்ட்ராக்ட் will happen. நான் நினைச்சு மும்பைக்கு ஃபிளைட் போட்டேன்னா 1 hourல கான்ட்ராக்ட் will happen. இதே நான் நினைக்கலன்னா மும்பைக்கு எனக்கு வழியே தெரியாதுன்னு சொல்லிட்டு நான் கூட வீட்டில் உட்காந்துருக்கலாம். Able to understand நான் என்ன பூரி சொல்றேன்னு? So whatever is in my 100% control, you cannot call it as a contingent event. Understood? But sometimes say for example I say a similar example but one small change. If government is sponsoring me to Mumbai, I will come and sell you the house. What? Government sponsors Mumbai, travel to Mumbai, then I will come and sell the good. அப்படின்னா கவர்மெண்ட் என்ன மும்பைக்கு ஸ்பான்சர் பண்றது என் கையில இருக்கா? என் கையில இல்லையா? என் கையில இல்ல. கவர்மெண்ட் ஸ்பான்சர் பண்ணாதான் I will come and sell the goods. So something which is there may be related to me but not in my full control. Not in my full control. This will come under contingent event. Okay, and that contract is called as contingency contract. What is that contract? Selling of Mumbai house to you. Adoda collateral event enna? Me getting a government sponsor to travel to Mumbai. Able to understand? Next one, example number 7. இந்த சாப்டர் பொறுத்த வரைக்கும் இன்னைக்கு வீட்டுக்கு போய் இன்னைக்கு நீங்க படிக்கணும், நாளைக்கு நீங்க படிக்கணும், நாளானைக்கும் படிக்கணும். அப்படி படிச்சாதான் இந்த பர்டிகுலர் சாப்டர்ல உனக்கு ஒரு grip கிடைக்கும். ஓகேவா? நீ கொஞ்சம் கேப் விட்டுட்ட அப்படின்னா it will be very difficult to think of all the examples which I told you, and நான் கொடுத்த எக்ஸாம்பிளுமே உனக்கு மறந்துடும். ஸோ இன்னைக்கே போயிட்டு நீங்க வீட்டில் உட்காந்து படிக்கணும். நெக்ஸ்ட் ஒன், example number 7. If A promises to pay 1 lakh if it rains on 1st April and A leave Delhi for Mumbai on a particular day is a contingent event, because going to Mumbai is an event no doubt within A's will, but raining is not merely his will. அப்போ இந்த இடத்துல ரெண்டு ஈவெண்ட் சொல்லியிருக்காங்க. There need not be one single event, there can be more than one event also. Okay, அதுல ஒரு ஈவெண்ட் என்ன, it should rain. Second event என்ன, I should go to Mumbai. Now இந்த ரெண்டு ஈவெண்ட்ல second event is in my control. Going to Mumbai or not is in 100% my control. ஆனா it should rain அப்படின்னும் போது it is not in my control. So therefore there is a contingency. Rain may come, rain may not come. If rain comes and I come to Mumbai, I will come and do the contract. Able to understand? Clear? So we are done with contingent event should not be a mere will of the promiser. In case ரெண்டு event பா, ரெண்டு eventல first event rain should come, I will perform the contract. Rain does not come, no, I will not perform the contract. இன்னொரு collateral event சொல்லிருக்காங்க என்ன, if I should come to Mumbai, I will perform the contract. அப்பனா ஒரு கான்ட்ராக்டுக்கு ரெண்டு collateral event கொடுத்திருக்காங்க. பட் நான் என்ன சொல்றேன்னா, rain மட்டும்தான் can be treated as a collateral event. Me coming to Mumbai or not cannot be treated as a collateral event. அப்ப எதுக்கு நீங்க இம்பார்ட்டன்ஸ் கொடுப்பீங்க அப்படின்னா, sir, if rain comes, contract will happen. Rain does not come, contract will never happen at all. Able to understand? Clear? So that is with respect to contingency event should not be the mere will of the promiser. And lastly, that event must be uncertain. Uncertain may happen, may not happen. Rain may come, may not come. Government may sponsor me, may not sponsor me. Able to understand? And the event oda control ennoda kaila kadiyadu. But in case first example na solla subsidiary example, என்னோட 100% சப்சிடரினா நான் என்ன சொன்னாலும் அது ஃபாலோ பண்ணி தான் ஆகும். There is no uncertainty there. But if at all that company, Japanese company, is an independent company, அதுக்கும் எனக்கும் இந்த buying selling of items தவிர வேற எதுவுமே ரிலேஷன்ஷிப் இல்லை அப்படின்னா, there is no bondage, there is no command of myself on that company. They need not follow my commands. Able to understand? அப்போ predominantly what you can say is, I am not able to control the company. The particular Japanese company sending me the goods on July 18th or receiving on July 18th or after July 18th, June 18th is not within my hands. Okay, I have an uncertainty. Purinjada? Please go through. I'll give you 5 minutes time. Please go through all the examples given in this area. Essentials of contingent contract. Each and every example, spend time and read. In here for this marriage, I want you to definitely do something like this. Put a chart so that you will not forget. Shall I scroll down? Done? Everyone done? Okay. Next one, rules relating to enforcement. Now, what do you mean by enforcement? We already know enforcement means to file a case. To file a case for non-performance. Now, in case of a contingency contract, when can you go and file a case? This is what we are going to study. என்ன படிக்க போறோம்? Contingency contractல எப்போ நம்ம போயிட்டு நான் பர்ஃபார்மன்ஸ்க்காக ஒருத்தர் மேல கேஸ் கொடுக்க முடியும். Okay, that is what we are going to see. First case is enforcement of contracts contingent on event happening. Event happening na enna? If it happens, say for example, my brother, you yourself and myself, we are entering into a loan agreement where I am giving you loan of say 15 lakhs to you. How much? 15 lakhs to each of you. Okay, but on a collateral event, what is that collateral event or condition? Only if I receive money from my brother. Able to understand? Only if I receive money from my brother, I will be giving you a loan of 15 lakh rupees. When you repay me, you should pay me along with interest. Okay, so performance in a giving you loan, consideration in a you repaying along with the interest. What is the collateral event? Only if I get the money from my brother. Okay, மூணு பேர். Now, what is the event, collateral event? Me getting money from my brother. It is a happening event or a non-happening event? May or may not, but mostly if it happens only, I should give you money. Yes or no? Yes or no? It is a event happening. So if it happens only, I will be giving you loan. Appo my contract is based on a contingency of happening of a event. And the event நடக்கும் நடக்காம போகும் secondary. Okay, ஆனா எப்படி என்னோட கான்ட்ராக்ட் நான் எப்படி ஃப்ரேஸ் பண்ணியிருக்கேன் அப்படின்னா, I will give you loan only if I receive it from my brother. Only if it happens, I will give you loan. So which means my contract is based on happening of a event. Happening of a event. அது நடக்கிறது நடக்காது, அது secondary thought. Able to understand? இப்போ நீங்க என் மேல கேஸ் போடணும் அப்படின்னா எப்போ நீங்க கேஸ் போடலாம்? எப்போ நீங்க கேஸ் போடுவீங்க? Anyone sent message? I got a. Did anyone send me any message? Google Meet la? No one, right? Okay. If you have to file a case on me, okay, ma'am, நீங்க தரேன்னு ப்ராமிஸ் பண்ணிட்டு என்ன தரல அப்படின்னு நீங்க எப்போ என் மேல போய் கேஸை ஃபைல் பண்ணலாம் அப்படின்னா, only after you coming to know that madam obviously அவங்க தம்பி கிட்ட இருந்து அமௌண்ட்டை வாங்கியிருக்காங்க. The event has happened. After event has happened also, she did not give me money. Only then you can go and file a case. Able to understand? ஒருவேளை என் தம்பி எனக்கு காசு தரல அப்படின்னா, will you be able to go and file a case? No, because my contingency contract is based on happening of an event. You can file a case only if that event has happened and I did not do the performance. Clear? Understood? Let us go read. Here we'll have to do minor changes. Follow with me. Where a contingent contract, what is the contract? You plus me, I should give you loan and you are receiving the loan, is made to do or not to do if an uncertain future event. What is that uncertain future event? Brother gives money, okay, happens. If it happens only, I can give you money. It can be enforced by law only if that event has happened. If the event becomes impossible, such contracts can become void in nature. Able to understand? Say for example, my brother has gone abroad. He is not planning to come to India itself. He is already earning only in say US dollars, Canadian dollars, abdina. Then there is no point that he will come back to India and give me the amount. Able to understand? Clear? So it could become void. Okay, let us read one more time. Where a contingent event or contingent contract is made to do or not to do. What is that to do? Give loan or not to give loan, and that is based on an uncertain future event happening. It can be enforced by law only if that event has happened. Purida. Let us go read the example. Mr. A contracts to pay B a sum of money when B marries C. C dies without being married to B. The contract becomes void. Sir, first of all, this cannot be a contingency contract because reason, this forms part of consideration. Nam already padchom. So this example, please scratch out. Wrong example. Next one, enforcement of contracts, contingent. See, if at all you do not have any book, please take today's recording. Once you get the book, please mark whatever changes we are doing. Very, very important. Okay. Now, second ma, please listen. Events that are contingent, contracts which are contingent on events that are not happening. Okay. Now, let us see the example which is given here. Mr. P agrees to pay Q. Now, who are the two people? Say Pavitra. Pavitra and Miss Queen or Perachikam. Okay. Agrees to pay a sum of money. If a particular ship does not return, the contract becomes enforceable only if the ship sinks so that it cannot return. Now, in here also, there should be some consideration. In the consideration pati, they did not talk. Or money is the consideration, but performance pati, they have not mentioned anything. Okay, but this money consideration and performance is based on a collateral event. What is that collateral event? Ship has to return. If the ship has to return only, or ship does not return within the specified time, now this person will not pay money. Able to understand? Sir, performance is separate, money is separate, but both of them are related to or collateral to this event. What is that event? Ship does not return. Now, my contingent contract is based on non-happening of a event. What is that? It should not happen. Ship should not return on certain date. Able to understand? Now, அந்த தேதிக்குள்ள அது வரல அப்படினா you can enforce it on me. You can enforce the particular case against me. If at all it has returned or there is no opportunity for the ship வந்து மூழ்கிருச்சு அப்படினா ship வச்சு தான் நீங்க collateral event வந்து பேசிட்டு இருக்கீங்க. அந்த ஷிப்பே காணோம், ஷிப்பே மூழ்கிருச்சு அப்படினா collateral event நடக்கிறதுக்கு வாய்ப்பே இல்ல. The contract could become void. Able to understand? Now, let us go read one by one. We will be able to understand line by line. Where a contingent contract is made to do or not to do anything if a uncertain future event does not happen, it can be enforced only when the happening of that event becomes impossible and not before. Sir, what is that they are trying to say, sir? Let us say, sir, Mr. A contracts with Mr. B, say for delivery of goods. Delivery of goods. Okay. And Mr. B is supposed to pay, say 10 lakh rupees. 10 lakh rupees. But this delivery of goods is based on the ship arrival. Ship arrival. Say the ship, contingent event is the ship does not come within June 15th abdina, then I will deliver only on July 1st. Able to understand? So two things can happen. One, ship varamale poidlam illa June 15th ku munnadi vandirlam. Now June 15th varaikkum varala abdina, then what is the contract that you are trying to do? If the ship is not coming within June 15th, you will be honoring the particular contract by July 1st. Now, what is that uncertain event? Ship coming. Okay. And what is the particular date that has been fixed? Happening or not happening? It should not happen within June 15th. Now, June 15th kulla idu nadandhathu abdina, then what is the probability? You cannot file any case. அப்போ June 15th க்கு மேல ship வரல அப்படினா, then what is the probability? What you will do? You should follow the particular contract. Able to understand? Now one more time I will repeat. Please listen. First one ko second one ko nariya confusion agum. Please listen one more time. Last time இதுக்கு மேல நானும் explain பண்ண மாட்டேன், நீயும் கேட்காத. புரியுதா? அப்படிலாம் இல்ல. You can ask me. Please listen. Please listen. Sir, two people are entering into contract for some delivery, and then he is supposed to pay some 10 lakh rupees based on a collateral event. Enna collateral event na? Ship arrival. Sir, when does the ship should arrive? Sir, the contract of the person A says the ship should not come within June 15th. If it doesn't come within June 15th na, then I will honor the contract on July 1st. Able to understand? Appo what should not happen? Ship should not come within June 15th. So in the edathila, when will the person have the right to file the case? Ship 15th தாண்டி வரல அப்படினா, then who's in the position? Who's in the favorable position to file a case? Mr. B is in a favorable position to buy the case. ஏனா உன்னோட condition என்ன? July 15th குள்ள வரைக்கும் ship வரக்கூடாது. ஆமா, June 15th வரைக்கும் ship வரல. So therefore, even after the ship did not come on June 15th, then if you are not performing, I can file a case. Able to understand? Clear? So where a contingent contract is made to do or not to do anything, if an uncertain future event does not happen, it can be enforced only when the happening of that event becomes impossible and not before. Clear? When will it become impossible? Yes.
Can you explain that B not filing a contract, eligibility of B filing a case again? The last one.
When will he file the case? Adhana. Sir, in this contract, what is the exact timeline, sir? What is the thing that should not happen? June 15th kulla ship should not return. Okay. Now, if it returns within that period abdina, then what can happen? I will not perform the contract. Now, in case if the ship has not yet come even after 15th abdina, then I am bound to do the contract. Correct? Appo, when I am bound to the contract, but still I am not doing abdina, then obviously the other party can file a case against me. Clear? Okay, va? Okay. Next one. A contract would cease to be enforceable. Cease to be enforceable now. Cannot be filed. Okay, cannot be filed case against it if it is contingent upon the conduct of a living person. Conduct of a living person when that living person does something to make the event or conduct as impossible of happening. There's a very good example. Good example சொல்ல முடியாது, காமெடியான ஒரு example கொடுத்திருக்காங்க. Let us go read now. Mr. A agrees to pay Mr. B a sum of money if B marries C. C marries D. Okay, now what is the contract? Now a contract is based on a living person. Who's that living person? C. Okay, this C has eventually married D. Okay, this act of Mr. C has rendered the event of marrying B C is impossible. It is though possible if there's a divorce between C and D. Okay, so what they are trying to say is, if you are making a contingency based on a living person and that living person has done something which eventually makes the entire contract impossible, then you cannot file a case on it. That is what they are trying to say. Okay, cease to be enforceable means you cannot file a case when you make a contract and that contract is contingent upon the activity of whom? A living person, and on the living person he has decided his own way and he has done some act which makes the entire contract impossible. Void up automatically the contract enna agum, it goes into void. Start reading now. If a contract is contingent upon how a person will act at an unspecified time, the event shall be considered to have become impossible when such person, yaar in the such person? C. Such person does anything which renders it impossible and that he should act within any definite time or otherwise than under further contingencies. Now, what we should write for exam? Stop it till impossible, the contract becomes void. More than sufficient. In the definite time, indefinite time, timeline that is given for filing a case. Further contingency. Adana further contingency. Inga kuduthirukanga per last line. This is the further contingency. If at all, see, adukaprom D kitta the divorce vaangi, adukaprom na kalyanam panni, idella can come under further contingencies. Okay. So for our exam purpose, stop it till here. It is impossible. Let us see a case law which is given here. The defendant promised to marry the plaintiff on the death of his father. While the father was still alive, he married another woman. It was held that it has become impossible and that he should marry the plaintiff, and she was entitled to sue him for the breach of the contract. Now, it was depending, the contract between F and K was based on what contingency, ma? Father's death. Father's death, correct? Now, who made the contract impossible? Father or the son? So father is still living. He did not do anything, correct? Contingency was on father's death. அது எப்ப வேணா நடக்கலாம். அதுல எனக்கு எந்த ஹோல்டும் கிடையாது. But before even the father dies, who went and married another person? The son went and married another person. Obviously, this comes under breach of contract. But if suppose father of that particular person, he did not die, he is not living, he is in coma stage. Coma stage le or 30 varsham, what is the position? He cannot do anything. Okay, in that case we cannot decide anything. The contract does not come to an end at all. It becomes impossible. Ultimately it goes into void. Seriya? Next one, contingency on happening of a specified event within a specified time. Now, this timeline is very, very important. For now, let us study all of these 7 points. In the 7 points, I have a chart that is written. Okay, I will give you the chart once I go home today. Refer that. Next class, once again, we will see this particular all 7 points. Written examples are there. If you apply the chart, you will get the final answer. Adiketha mari your solution can be written. Okay. but I'll explain you what they are trying to say. First case la enna padichom, contingency on a happening event, correct? Only if that event happens you will file a case on me, okay na? What is my promise? Only if it happens I will do the activity abdina. If it happens only you can also file a case, correct? அதே போல second contingency ல என்ன பார்த்தோம்னா, my contract is based on non happening of a event, அப்போ when can you file a case? When I am bound to do, when will I bound to perform? When the event does not happen. So you will also file a case when the event does not happen and I am not perform the contract, okay? Now what we are studying is happening of an event da, ana for that I am giving you a timeline for that, okay? Let us read. Mr. A promises to be a sum of money if certain ship returns within a year. Now what is the two things that we should be sure of is it is happening of an event, another return of the ship. ஆனா விஷயம் என்னன்னா, for that a timeline is attached. What is the timeline ma? Within a year. அப்போ if at all the ship comes within a year only I am bound to perform. Yes or no? அப்போ only if it comes within a year only you should also file a case against me. Able to understand? Sir, ship 1 year தாண்டியும் வரவே இல்ல, will you file a case against me? There is no need to file a case against me. Sir, ship மூழ்கிடுச்சு, will you file a case against me? No, you cannot file a case against me. The contract goes void. ஏனா ஷிப்பே இல்ல, கடல்லே இல்ல. Able to understand? Clear? One more time. Listen. We are talking about contract based on a contingency event which is to happen, and for that we have a fixed time. Sir, in case we are contracting for based on a contingent event which should happen abdina, you will I will perform only if that event happens. That event happens and I did not perform now, when you will file a case? Only if that event happens. அது happen ஆனாதான் I am bound to perform. அப்படினா happen ஆயும் bound perform பண்ணல அப்படினா you will file a case against me. But bound to happen, ஆனா அந்த happeningக்கு ஒரு time frame கொடுத்திருக்காங்க. What is the time frame? 1 year அப்படினும் போது ship should return and it should return within 1 year அப்படினா, then if it happens you will also file case within that time period only. If the time period exceeds 1 year அப்புறம் case, 1 year அப்புறம் தான் ship வருது அப்படின்ற போது, then the contingency itself is not happening, so I need not perform the contract. Let us go read. The contingency contract to do or not to do anything if a specified uncertain event happens within a fixed time. What is that specified event? Ship returning. Ship should return. It should happen. Okay, and it should happen within a fixed time. It becomes void if at the expiration of the time period and such event has not happened, or if before the time fixed such event becomes impossible. About what is the only time period when you can file a case? If it returns within the timeline. If it does not return within the timeline or returns it has expired the timeline abdina, 1 year and 2 days ஆயிடுச்சு sir return ஆவறதுக்கு, 2 days extra time ஆயிடுச்சு, will you be able to file a case against me? No. Sir, ship has sunk sir, will you be able to file a case against me? No. Second one, contingent upon a event not happening within a fixed time. Sir, only difference is earlier one my contract was if ship returns within 1 year. Second, my contract was if the ship does not return within 1 year, I will come and perform. Okay. So, when will you file a case against me? Or when is the time bound to do the performance? If it exceeds 1 year. If it exceeds 1 year only, I am bound to perform. So, when will you file a case against me? After 1 year. 1 year kulla varalana you will be able to file a case. Correct? When will the contract become void? If it comes within 1 year, the contract becomes void. I need not perform the contract. Sir, varadhukku munnadiye ship sink aichna. Ship sink aanalum 1 year kulla vara poradilla. Correct? End of the day, the contract will not be performed. Not be performed. ஏன்னா ship sink ஆயிடுச்சு, ship வர போறது இல்ல. Obviously, the contract should be performed by me. I cannot escape. Clear? Understood? So, even if it is not relatable for you for now, hold on. Next class, I will come with the chart. Contingency of an impossible event, we already know it is void. Difference between contingent event and wagering event kuduthirukanga. Now, I want you to read this, at least read this and understand. Wherever you are struggling, I will come for help. Start reading. Yeah. Yes. என்னது கேக்கல? Second point number 2. Sir, in case of a wagering agreement, there are two promises. One, if I lose, I will pay. You lose, na, you will pay me. Correct? In case of a contingent contract, my contract itself is based on a collateral event, and this collateral event may happen or may not happen. If it happens, na, the contract will be good, both the parties will perform. If the collateral event does not happen, abdina, both the parties will not perform. Or to be precise, one party will say the contract cannot be performed because the collateral event does not happen. But even though the other party may have the interest to perform the contract. Take the example of first one, loan example. Sir, your interest is to take loan from me. Ungaloda viruppam enna to take the loan from me. Ana I am ready to give my loan or enter into a loan contract only if I receive it from my brother. If I do not receive abdina, then I will not give you any contract or any loan, say for that matter. In this case, I am not interested to give loan. However, you may be interested to receive the loan. In this case, first case, there is reciprocal promise. Both the parties will come together and make a promise. But in case of a collateral agreement where we are agreeing for a contingent event which may not happen, if it does not happen, one party will not be interested to perform the promise. The other party may be of interest to perform the promise.
Contingent contract la vandu the event that will happen, the collateral event is important. Wagering agreement la vandu the game of winning or losing.
In wagering, winning or losing is the only activity, correct? ஆனா contingent contractல ரெண்டு ஆக்டிவிட்டி இருக்கு. ஒன்னு the contract itself, இன்னொன்னு the collateral event. Only if the collateral event happens or does not happen, it is based on that we enter or we further continue with the contract. Understood? So collateral event highlight, it should be highlighted. If the collateral event is happens, then you will continue the contract. If the collateral event does not happen, you will not continue the contract.
Yes, that was great. I think if collateral event also there is a event to happen in a contingent contract.
ஆமா wagering அப்படி கிடையாது. Wageringல அப்படி கிடையாது. The moment you lose, immediately you have to pay money. அவ்வளவுதான். You pay money, after there's nothing to do. Yes, uncertain event. Have you done with this point? Done. Nature of contract. Done. Interest. Done. Interest na na.
What the party is paying from that.
In fact, what is my benefit attached to that particular activity? Okay. So yeah, that is called as interest. Okay. In case of a wagering, is there any personal interest? No. For a wagering, there cannot be any personal interest on what? On that particular activity, except for the winning amount. தவிர வேற எந்த personal interest உங்களுக்கு இருக்கக்கூடாது. ஆனா collateral or contingent contractல you should be interested in that particular collateral event. Okay va? This mutuality of loss and gain. Yes, done now. So this area is done for you. Next one, quasi-contract. Now, what is a quasi-contract? We already know quasi-contract is not an actual contract, but it looks like a contract and created by law. The parties to the contract may know each other or may not know each other, but they are bound to each of them. Able to understand? So this is called as quasi-contracts. Now, under quasi-contracts, we have certain things to understand. Let us start reading. What are the salient features of quasi-contract? In the first place, such right is always a right to money, and generally, though not always, it is a liquidated sum of money. What is a liquidated sum of money? Liquidated sum of money means something that is liquidated money la ready cash la, something that is identifiable. Something that is identifiable. Say for example, I spent 500 rupees for as auto expenses, 1000 rupees to search you, and what is the identifiable expense that I have met to find you? 1000 rupees. Able to understand? And what is that I can recover from you? 1000 rupees. Okay. Now there's some amount. It is always an amount usually, and that amount is identifiable, so that you can recover from the opposite party. Okay, first point, start reading. Such a right is always a right to money. Right to money, and it is to a liquidated sum of money. Okay. Secondly, it does not arise from any agreement to the parties, but it is imposed by law. This point, is that a new point to you, or you already know it? You already know this point, because these people could be unknown people also. Example, you have lost something on the road, okay, and the other person finds it. He will take, open and see whatever label, poster, ID card inside, and he will fetch it to you, isn't it? Now, the moment he takes it, can he put it inside his pocket and walk away? If he is doing that, it is called theft. Able to understand? If he is finding you and delivering it to you, and even though you people are unknown to each other, the law puts a contract between you. You are bound to pay him whatever cost he has met, and like the way he is also bound to return the particular item to you, whatever you have lost it. Thirdly, start reading. It is a right which is available not against all the world but against a particular person or persons only, so that in this respect it resembles a contractual right. Which means, sir, in the road you saw a small wallet, okay, you are picking it up, okay, pick up பண்ணிட்டு இத அதோட அட்ரஸ் எல்லாம் தேடி you are going and giving it to a old person கண்ணாடிலாம் போட்டுருக்காரு. Okay, now this person is the actual owner. Okay, say his family members are here. நீங்க அவரோட வீட்டுக்கு போறீங்க, வீட்ல ஓனர் இல்ல, வீட்ல அவரோட ஃபேமிலி மெம்பர்ஸ் இருக்கீங்க. இந்த பர்ஸ ஒரிஜினல் பர்சன் கிட்ட கொடுப்பீங்களா இல்ல ஃபேமிலி மெம்பர் கிட்ட தான் கொடுப்பீங்களா? ஐடி கார்டுல அட்ரஸ் இருக்குப்பா, அந்த அட்ரஸ்க்கு நீங்க போறீங்க, அந்த அட்ரஸ்ல இந்த போட்டோல இருக்க ஆள் அங்க இல்ல. ஓகே, வீட்டுக்கு போறீங்க, வீட்ல ஃபேமிலி மெம்பர்ஸ் இருக்காங்க. இப்போ ஒண்ணு அந்த ஃபேமிலி மெம்பர் கிட்ட நீங்க கொடுத்துட்டு வரலாம், இல்லனா அந்த ஓனர் கிட்ட கொடுக்கலாம். இது ரெண்டுத்துல எது கரெக்ட்? most appropriate will be handing it over to the owner himself. யார் அந்த பர்சனோ அந்த பர்சன் கிட்ட கொடுக்கறது தான் கரெக்ட். இல்ல அப்படின்னா you should make a confirmation with the family. Able to understand? இப்போ ஃபேமிலி கிட்ட எப்படி நீங்க கன்ஃபர்மேஷன் பண்ணுவீங்க? பேரை சொல்வீங்க, போட்டோவை காட்டுவீங்க, இவர் இந்த வீட்டுல இருக்காரா அப்படின்னு சொல்லி நீங்க கேட்பீங்க. கரெக்டா? அவங்க ஆமான்னு சொல்றதுக்கு நிறைய வாய்ப்பு இருக்கு. ஆனா அதை எப்படி நீங்க நம்புவீங்க? ஒண்ணு அவங்க வீட்டுல ஏதாவது ஃபேமிலி போட்டோ இருந்திருக்கணும், அந்த ஃபேமிலி போட்டோல இந்த ஆள் முகம் தெரிஞ்சிருக்கணும், அப்படின்னா நம்பலாம். கரெக்டா? சரி, பர்ஸோட கலர் என்ன அப்படின்னு சொல்லி கேள்வி கேட்கலாம். பர்ஸுக்குள்ள வேற என்னென்ன இம்பார்ட்டன்ட் ஐட்டம்ஸ் இருந்து சொல்லுங்க அப்படின்னு சொல்லி கேள்வி கேட்கலாம். கரெக்டா? ஆனா இதெல்லாம் பண்றதோட எனக்கு தெரிஞ்சு நீங்க ஏதாவது ஒரு கவர்மெண்ட் டாக்குமெண்ட் கேட்கலாம். எஸ் ஆர் நோ? எதுல கவர்மெண்ட் டாக்குமெண்ட்ல ஃபேமிலியோட ஃபுல் டீடைல்ஸ் இருக்கும், ரேஷன் கார்டுல இருக்கும். கரெக்டா? ஃபேமிலி போட்டோஸ்ல இருக்கும். அப்படியெல்லாம் இருக்கும் பட்சத்துல யூ கேன் சே தட் திஸ் பர்டிகுலர் ஓனர் ஆஃப் த வாலெட் பிலாங்ஸ் டு திஸ் ஃபேமிலி அண்ட் யூ கேன் ஹேண்ட் ஓவர். ஒருவேளை அந்த ஃபேமிலி ரேஷன் கார்டு இல்ல சார் சொல்லிட்டாங்க, ஃபேமிலி போட்டோ எங்க வாழ்க்கையில நாங்க ஃபேமிலி போட்டோ எடுக்கல சார் அப்படின்ட்டாங்க, அப்படின்னா whether that family can still claim the wallet? No. Reason என்ன அப்படின்னா, logically you are bound to give the particular wallet only to the owner by the law. Yes or no? It is a right against only that one person. Okay, it is not a right against the entire world. அப்போ அந்த ஓனரை தவிர நீங்க அந்த வாலெட்டை யாருக்கும் கொடுக்க வேணும்ன்ற அவசியம் கிடையாது. Okay, that is why it is called as it is a right against one single person. Okay, and it is not for the entire world. Clear? Ma'am, அப்ப அந்த ஃபேமிலி மெம்பர் வந்து எங்க மேல கேஸ் போட்டா என்ன சொல்லும்? என்ன பண்றது? மா ஃபேமிலி மெம்பர் உங்க மேல கேஸ் போட்டா கூட law comes and stands with you only. It will say that you are a person in quasi contract. This is not actual contract, but still you are under a contract and the contracting party is the owner of the wallet. You are bound to deliver only to the owner. You are responsible only to the owner. You are not responsible to any third person or even the entire world as such. So அந்த பர்ஸை கிளைம் பண்ணி உலகமே வந்தா கூட you need not give the purse. You are responsible, you are rightful only to pay it to the original owner. Understood? Shall we read together? Yes. It is a right which is not available against the world but against a particular person or persons only, so that in this respect it resembles a contractual right. In case owner வந்து கேட்டதுக்கு அப்புறம் ஓனர் கிட்ட நீங்க தர மாட்டேன்னு சொன்னீங்கன்னா then what is the possibility? Owner has all the right in the world to file a case against you. Able to understand? Yes. Now under this, next area is cases which are deemed to be quasi contracts. So the cases which are deemed to be quasi contracts. First one, claim for supplies necessaries. Start reading. Claims for necessaries supplied. Okay. Now under 68 we already studied. Based on this you faced a question when you wrote a test. When you wrote a test you faced a question. Precise சொல்ல போனோம் அப்படின்னா a person aged 21 years of age who becomes lunatic and has to take care about take care of a grandmother. Test age ne illaya nee baban mulikira grandmother, and he has a brother or sister something. அந்த மாதிரி ஒரு question கொடுத்திருந்தாங்க. Now earlier chapter la we saw minor supplies ku or minor oda necessities ku when we supply something, the supplier can receive money to what extent? Whatever property he has inherited, or அந்த particular minor ku என்னென்ன property இருக்கோ அந்த property வரைக்கும் this supplier can take money. அந்த ப்ராப்பர்ட்டியை தாண்டி நீங்க சப்ளை பண்றீங்க அப்படின்னா you cannot take any money. இதுதான் நம்ம மைனர்ல படிச்சோம், கரெக்டா? சேம் provision applies for all other incapable person. Who are other incapable persons? Insane person, lunatic, insane, all comes under same category. The people disqualified by law, intoxicated person, all of this will come under other parties who are not or disqualified by law. All these are incapacitated people. So avungalku ellarkum endha provision varum? Quasi contract. It comes under quasi contract. Here also this particular supplier of necessaries should be giving only to the extent of the inherited property by such lunatic, by such incapacitated person. Beyond the inherited capacity, if the supplier is giving any goods, he will not be able to recover it. Okay, so claims for necessaries supplied, section 68. Just like for minor, here this section 68 comes for other incapacitated person. Now this comes under unit number 6. appo yen ma'am test ku vechinga, some mistake happened, sorry for that. Next one, payment by an interested person. Next one, obligation of a person enjoying the benefit of non-gracious actor, responsibility of finder of goods, money paid by mistake or under version. Each item let us go in detail and see. This one I already explained. I will give you 2 minutes time. Please go through. Claim for necessaries supplied. Shall we read? If a person, yarpa and the person, incapable person, lunatic person, also other, incapable of entering into a contract, or anyone whom he is legally bound to support. அப்போ அந்த lunatic ஓட grandparent, அப்புறம் அவங்களோட minor siblings எல்லாருமே, is supplied by another person with necessaries suited to his condition in life. What does you mean by suited to his condition? அவர் எந்த பொசிஷன் ஆஃப் சொசைட்டில இருக்காரோ அந்த பொசிஷன் ஆஃப் சொசைட்டிக்கு ஏற்ற மாதிரி அவருக்கு நெசசரிஸ் கொடுக்கும் பட்சத்துல, the person who has furnished such necessaries, given such supplies, is entitled to be reimbursed from the property of such incapable person. Clear? To establish his claim, the supplier must prove not only that the goods were provided to that minor or lunatic, but also those were suitable for his actual requirements at the time of sale and delivery. So at that time, அந்த particular insane person க்கு அது ஒரு requirement இருந்திருக்கும், அது ஒரு need இருந்திருக்கும். It should not be a luxury and it should suit his condition of life. Clear? Understood? Shall we go to the next area? Next one, payment by an interested person. Now you need to know what is or who is a interested person. Let me give you an example. So say for example, you are living in a house or house van. You are living in a, you are running a business. You are running a big manufacturing unit. Now this manufacturing unit is taken on lease, lease period is for 10 years and lease amount was 10 crore rupees. எவ்வளோ 10 crores. Okay, 10 years, 20 years lease amount வந்து 10 crore rupees is the lease amount. Now all of a sudden நீங்க full manufacturing எல்லா manufacturing யூனிட் செட்டப் பண்ணிட்டீங்க. அடுத்த 20 இயர்ஸ்க்கு தேவையான மிஷினரி ஷெட் அது இது எல்லாமே போட்டாச்சு. ஓகே, now there comes a government notice. Notice என்ன சொல்லுது அப்படின்னா, சார் there's a revenue arrear. Revenue arrearனா என்ன? ப்ராப்பர்ட்டி டாக்ஸ் பே பண்ணிருக்க மாட்டாங்க அந்த லேண்டுக்கு, வாட்டர் டாக்ஸ் பே பண்ணிருக்க மாட்டாங்க, சூவேஜ் டாக்ஸ் பே பண்ணிருக்க மாட்டாங்க, ஏதாவது ஒரு டாக்ஸ் வந்து which he should have paid. ஹீனா யாரு? ஓனர் ஆஃப் தட் பர்டிகுலர் லேண்ட். அதை யாரு பே பண்ணிருக்கணுமோ அதை பே பண்ணாம விட்டுட்டாங்க. அதனால கவர்மெண்ட் ஹஸ் சென்ட் நோட்டீஸ் டு த பர்டிகுலர் ப்ராப்பர்ட்டி. என்ன பண்ணுவாங்க? ப்ராப்பர்ட்டி ஃபர்ஸ்ட் 2 டைம் வந்து ஓனர் வீட்டுக்கு அனுப்புவாங்க நோட்டீஸ். அதுக்கடுத்து இன்னொரு டைம் என்ன பண்ணுவாங்க? எந்த இடம் இருக்கோ அந்த இடத்தோட வாசப்படியில வந்து போஸ்டர் ஓட்டுவாங்க. இந்த மாதிரி இந்த இடத்துல இந்த கவர்மெண்ட்டுக்கு இந்த ஸ்டேட் கவர்மெண்ட்டுக்கு இவ்வளோ ரெவென்யூ வந்து இவங்க பே பண்ணாம இருக்காங்க டாக்ஸ். ஸோ இன்னும் 2 மாசத்துக்குள்ள பே பண்ணல அப்படின்னா திஸ் பிளேஸ் வில் பி லாக்டு, நோ ஒன் கேன் யூஸ் திஸ் பிளேஸ் அப்படின்னு சொல்லி தே வில் புட் அ நோட்டீஸ். இப்போ இந்த நோட்டீஸ் போட்டா who will be the most affected person? Land owner or the manufacturer? யாரு?
The person setting up the manufacturing.
The manufacturer will be the most affected person. ஏனா he has paid full 10 crores 20 yearsக்கு லீஸ் எடுத்துட்டு இருக்கேன். லீஸ் எடுத்தது மட்டும் இல்லாம I have put my full setup, full manufacturing setup. இப்போ கவர்மெண்ட் வந்து நோட்டீஸ் ஒட்டிட்டு இன்னும் 2 மாசத்துல வந்து பேமெண்ட் பண்ணலன்னா ஃபுல் பிளேஸும் வில் பி லாக்ட் அப் அப்படின்னா then manufacturer will be the most affected person. Yes or no? Now he wants to protect his interest. What he will do is, sir, 10 crore lease amount pay பண்ண தெரிஞ்ச எனக்கு ஒரு 10 lakh rupees கவர்மெண்ட்டுக்கு டாக்ஸா பே பண்ண முடியாதா? Will I pay it or not to save my position? I will definitely pay. ஓகே, இல்ல லேண்ட் ஓனர் கட்டுற வரைக்கும் நான் வெயிட் பண்ணனா எனக்கு தான் அது ப்ராப்ளம் இல்லையா? பிகாஸ் ஐ எம் த மோஸ்ட் இன்ட்ரெஸ்டட் பர்சன் இன் திஸ் பர்டிகுலர் ப்ராப்பர்ட்டி. ஸோ டு ப்ரொடெக்ட் மை இன்ட்ரெஸ்ட் ஐ வில் டேக் மை மணி அண்ட் பே டு த கவர்மெண்ட். கரெக்டா? நவ் ஆஃப்டர் பேயிங் மை மணி should I keep quiet or I should recover it from the landowner? I should recover it from the landowner. Now owner will come and ask, நான் உன்னை பே பண்ண சொன்னா நீ ஏன் பே பண்ண? நான் எப்ப வேணுமோ நான் பே பண்ணிப்பேன் அப்படின்னு சொல்ல முடியுமா? சொல்ல முடியாது. அப்படின்னு யார் சொல்றதுன்னா law is saying that. Able to understand? Law says even though there is no contract between the tenant and the owner to pay this tax, however the tenant has paid the tax and it becomes the duty of the owner to repay the tenant with whatever amount that he has paid. In our case he has paid 10 lakh rupees and who's bound to repay it? House owner. He cannot come and ask எங்க கான்ட்ராக்ட் என்ன பேமெண்ட் அப்படின்லாம் கேட்க முடியாது. It is a quasi contract. It is a quasi contract. Let us go read word by word. We should read ma. A person who is interested. Now who is that person interested ma? நம்ம கேஸ்ல manufacturer who is interested in the payment of money which another is bound to pay by law. Who is this other person? Owner is the person who is actually bound to pay and who therefore pays it is entitled to be reimbursed by the other, who is nothing but the owner of the property. Clear? Understood? Shall we go to the next area? I'll give you 1 minute time. Please go through. Same thing is given as an example here. Same thing given as an example. Mr. B, do you want to go through with the example or you will read on your own? Okay, let us go through 1 minute. Just 1 minute, we'll do it and then go to the other point. Mr. B holds a land in Bengal on lease granted by A. அப்போ இந்த manufacturer யாரு? B. Okay, owner யாரு? Owner is A. Owner A and A, manufacturer is B. The zamindar. the revenue payable by A, who is the owner, to the government being in arrear, அப்படின்னா என்ன அர்த்தம்? It is not paid, it is still pending. His land is advertised for sale by the government. Government has announced for auction. Under the revenue law, the consequence of the sale will be annulment of B's lease. Annulment of B's lease means B oda lease will come to end. B lease period இன்னும் 10 வருஷம் இருக்கு remaining. ஆனா the land once it is sold by the government, the lease automatically comes to end. B, who is the manufacturer, to prevent the sale and the consequent annulment of his own lease, pays to the government the sum due from A, and now the owner, who is A, is bound to make the payment to B. Able to understand? Even though there is no contract between A and B to receive this tax amount, it is a quasi contract imposed by law, and the owner of the property is bound to pay the amount to the tenant. Understood? Clear? Shall we go to the next one? Okay. Next item, obligation of a person enjoying benefits of a non-gracious act. Sir, say for example, sir, I have done something for you. Okay, something for you, and in my mind, I'm not planning to do it free of cost. I want to charge some money, and we have not identified what is the money. Say for example, ma, you are writing me, you are helping me to type my book. You are my student, okay? Once you are finished with foundation and all, I am asking, can you do this for me? Type one page and give. No, I cannot type for today. I have other work to do. இன்னைக்கு ஒரு நாள் இந்த 2 பேஜ் ப்ளீஸ் டைப் அண்ட் கிவ். ஓகே, இந்த 2 பேஜை டைப் பண்றதுக்கு உனக்கு 3 hours ஆயிருக்குன்னு வச்சுக்கேன். End of that, you are giving me the pages also, and in that, ma'am, நீங்க ஏதாவது தந்தீங்கன்னா நல்லா இருக்கும் அப்படின்னு சொல்றீங்க. Okay, which means what அப்படின்னா, you don't want to do it graciously அப்படின்னு அர்த்தம். The moment you have done a work and your intention is to not to do it graciously, even though we have not agreed for any amount, by law, what law? Quasi contract, I am supposed to pay you some money. Okay, அப்ப அந்த டைம்ல நான் வந்து கேள்வி கேட்க முடியாது. ஏன் நீ நான் அந்த ஒர்க்கை கொடுக்கும்போது நீ ஏன் வந்து சார்ஜ் பண்ண போறேன்னு சொல்ல, நீ ஏன் இப்போ வந்து கேட்குற, நீ எனக்கு ஃப்ரீயா பண்ணி தர போறேன்னு தான் நான் நினைச்சிட்டு இருந்தேன் அப்படிலாம் நான் சொல்ல முடியாது. The moment your intention is to not do it freely, obviously, even though we have not agreed for a certain amount, I should be paying you some amount, and this comes under what law? Quasi contract. Yes, start reading. Where a person lawfully does anything for another. Who is that person doing? It is the student. Okay, inga and the red pen. It is the student, and for the other yaar, it is the ma'am or teacher, or delivers anything to him, not intending to do so gracious, meaning not intending to do freely. He wants to charge some money, and such other person yaar, faculty, okay, enjoys the benefit thereof. The latter is bound to pay compensation. Latter yarima? Teacher or faculty is bound to pay compensation to the former. Who's the former person? Student. Okay, in respect thereof, to restore all the things so done or delivered, even though there is no particular amount. If at all we have fixed a particular amount, it comes under consideration. No, நான் உங்களுக்கு டைப் பண்ணுங்கன்னு சொல்லி 2 பேஜை கொடுக்கும் போதே I will pay per page, I will give you 100 rupees அப்படின்னா, it forms part of consideration. So at that time, we did not, both of us, we did not talk in terms of consideration. But after doing the work, if your intention is not to do freely, and if you are asking money, I should be giving money, and it should be some reasonable amount. It need not be 100 rupees, but at least 70 rupees. Able to understand? Yes. It thus follows that for a suit to succeed, the plaintiff must prove. The plaintiff into the yarna student. Student must prove that he had done the act or had delivered the thing lawfully, and he did not do so graciously, he did not want to do it freely, and that the other person has enjoyed the benefit. These 3 things you have to prove it. Who has to prove? The student has to prove it, so you can file a case against the faculty and recover the money. Clear? Understood? Shall we go read this one more time? Okay, let me erase everything. You will keep in mind this person, other person, a person, adala yaar solno, neenga da solno. I will keep my mouth shut. Understood? Will you say it to me? Yes. Where a person, in a person, student, lawfully does anything for the other, faculty, or delivers anything to him, not intending to do so gracious, meaning he doesn't want to do freely, and such other person, the faculty, enjoys the benefit thereunder. Obviously, the latter is bound to pay compensation to the former. Stop it here. For exam also, stop it here. Understood? If at all you want to take it to the court and file a case, who should prove? The doer of the job should prove that he has done the job lawfully and he does not want to do it graciously, and the other person has enjoyed the benefit. Clear? Understood? So far we have seen 3 items under contract, quasi contract. First one enama?
Incapability of a person.
Incapable person. Second one?
Interested party.
Second one yare? Interested party. Third one enna? Person enjoying non-gracious act. Person enjoying a non-gracious act. Now for this they have given a case law also. Let us read the case law. Where a government servant was compulsorily retired by the government. Compulsory retirement எப்போ கொடுப்பாங்கன்னு நினைக்கிறீங்க? ஏதாவது ஒரு wrong compulsory retirement வந்து once they attain the age of retirement and automatically they will become retired. Compulsory retirement na before the age of retirement compulsorily the officer is pushing you out. When they will push you out of the door, if you are doing something mischievous, if you are taking bribe, if you are doing any act which is not in the interest of the company. Sir, company குள்ளேயே இருந்துட்டு கம்பெனியோட இன்ஃபர்மேஷன்லாம் வெளியே அனுப்புறீங்க அப்படின்னா என்ன அர்த்தம்? You are not acting in good faith. You are acting against the interest of the company. So obviously you will be sent out. He filed a writ petition and obtained an injunction against the order. Injunction என்ன? Already படிச்சோம். Injunction என்ன? Stay order. Stay order எதுக்கு வாங்கியிருக்காங்க? சார், நான் கம்பெனியோட ஓனர், நீங்கள் கம்பெனியில் ஏதோ பண்ணக்கூடாத வேலையை பண்ணிட்டீங்க, அது எதுவும் வேணா வச்சுக்கோ, ஓகே, ஹராஸ்மெண்ட்டு, விமன் ஹராஸ்மெண்ட்டு, என்ன வேணா வச்சுக்கோங்க. வாட் யூ ஷுட் நாட் ஹவ் டன், யூ ஹவ் டன் இட். ஸோ டு பனிஷ் யூ ஐ எம் சென்டிங் யூ அவுட். ஐ எம் சென்டிங் யூ வித் த ஆர்டர். என்ன ஆர்டர் அப்படின்னா, யூ ஷுட் பி அவுட் ஆஃப் எம்ப்ளாய்மெண்ட் ஃப்ரம் திஸ் பர்டிகுலர் டேட். யூ ஆர் நாட் அன் எம்ப்ளாயி எனிமோர். இந்த ஆர்டருக்கு அகேன்ஸ்டா this employee went to court and filed the case and got an injunction order. Injunction order na இந்த ஆர்டருக்கு ஸ்டே ஆர்டர். அப்படின்னா என்ன அர்த்தம்னா, கோர்ட் கடைசியா வெர்டிக்ட் கொடுக்கிற வரைக்கும் I will still continue in the company. He was reinstated. Reinstated means he started working inside the same company and was paid salary but was given no job. Sir, கம்பெனிக்குள்ள காலையில 9 மணிக்கு வந்துட்டு ஈவினிங் 6 மணிக்கு கிளம்ப வேண்டியதுதான். And for that he has been given salary. Work was not given at all until the court judgment was given. The appeal was decided in favor of the government and K was directed to return the salary paid to him during the period of reinstatement. Reason enna, sir, who was enjoying the benefit, sir? Employee, correct? And who was the person who was not going to give the salary for free? The owner of the company. So long what was happening abdina, this owner was keep giving money, and in turn what is that employee giving? Nothing. He came 9, went out 5. Okay, he was just enjoying the benefits. What benefits? Salary benefits. In turn he did not give any work. Okay, abdina, so far he was giving money and he was receiving money with no work in his hand. So when he is about to leave the company after final judgment, the judge told, so far you were receiving the amount graciously, free-ஆ வாங்கிட்டு இருந்த salary. ஆனா ஓனருக்கு உங்களுக்கு free salary கொடுக்கிற எந்த இன்டென்ஷனும் கிடையாது. Therefore you should give back the money because so much period you have not given any work also. Clear? Any doubt here? No doubt. Others, people online.
No doubt.
Shall we continue? Yes. Next one, responsibility of finder of the goods. Now this is very very important because it comes frequently in the case study based question. Now in the finder of goods நம்ம எக்கச்சக்க டைம் பார்த்துறோம், கரெக்டா? I will give you 2 minutes time. You sit and read word by word. You should be able to understand who's a person, who's this other and all, and come to a conclusion how this comes under quasi contract. இதெல்லாம் நம்ம ஆல்ரெடி நிறைய இடத்துல டிஸ்கஸ் பண்ணிட்டோம். எஸ், time for you to read. No right to use the goods. Appropriate means no right to use. Sir, watch கீழே கிடைக்குது, அதை எடுத்து நான் கையில கட்டிட்டு ஊர் சுத்த முடியுமா? 2 days ஆகுது உங்களை கண்டுபிடிக்கிற, 2 days வரைக்கும் நான் வாட்சை என்ஜாய் பண்ணேன்னு கையில கட்டிக்க முடியுமா? I should not use the goods. Done. So as a finder of lost goods, what he should do? 3 things: to take care of the goods, should not use the goods, and to give back the goods when the original owner is found. What is the 3 things that he should do, ma? 1, take care of the goods. அதுவும் எப்படி? Take proper care of the goods. Next, use பண்ணக்கூடாது. Original owner வந்ததும் you should return it to the original owner. Now, based on this, we have one case law and one example. Let me explain both of them. You can go home and read. In the particular case law, what happened abdina, sir, there is a shop, or say for example a restaurant is there. Okay, in the restaurant la ஒரு customer வந்து ஒரு டேபிள்ல உட்கார்றாரு. அந்த டேபிள்ல உட்கார்ந்து பேசிட்டே இருக்கும்போது or whatever work he is doing, he left his watch on the table or somewhere, அவருக்கே தெரியாம அந்த வாட்ச் அவர் கையில இருந்து கீழே விழுந்துருச்சு. கீழே விழுந்ததை கவனிக்காம அவர் பாட்டுல கிளம்பி போயிட்டாரு. ஓகே, இந்த வாட்ச அந்த பக்கம் வர சர்வர், ஃபுட் சர்வ் பண்ணுவாங்க இல்லையா, அவர் கண்டுபிடிச்சு எடுக்கிறாரு. கண்டுபிடிச்சு எடுத்துட்டு வந்து யார்கிட்ட கொடுப்பாரு? ரெஸ்டாரண்ட் ஓனர் கிட்ட கொடுப்பாரு. என்னன்னு சொல்லி கொடுப்பாரு? கண்டுபிடிச்சா இன்கேஸ் கஸ்டமர் வந்தா கொடுத்துருங்கன்னு சொல்லி கொடுப்பாரு. ஓகே, likewise he went and gave it to the manager. Now whether this activity is correct or wrong அப்படின்னா, first this activity is wrong. Sir, as a finder of the lost good, who was the finder? Server. Finder of the lost goods should give it back only to the owner or any other person? Only the owner. அப்போ இந்த இடத்துல even though the server is giving it to the manager, is the manager have the right to receive the particular watch? He does not have any right. நீ குடுக்கலனா நான் உங்களை வேலையை விட்டு தூக்கிடுவேன் அப்படின்னு சொல்ல முடியுமா? சொல்ல முடியாது. லா பிரகாரம் சொல்ல முடியாது. Able to understand? Clear? அப்போ until the owner comes and asks, who is acting as the owner? Servant. Able to understand? Ma'am, owner கண்டுபிடிக்க முடியலனா the particular goods belong to server only. ஓகே, நான் தான் மேனேஜர், நான் தான் ரெஸ்டாரண்டோட ஓனர், ரெஸ்டாரண்ட்ல எந்த பொருள் எங்க விழுந்தாலும் அது எனக்கு தான் சொந்தம் அப்படின்லாம் சொல்ல முடியாது. Whoever finds the lost good, he is the owner until he finds the original owner. And the finder of lost goods against no other person in the world can come and ask for the goods except for whom? Except for the original owner. புரியுதா? சார் டிஐஜியே வந்து கேட்டாரு, தர முடியாது. சார் ஜட்ஜ் வந்து கேட்கிறாரு, still you can say I will not give. Able to understand? கடவுளே வந்து கேட்கிறாரு, law says don't give it to God also. You only should keep it with you. Able to understand? Until when? Until the original owner comes and asks for it. Okay, va? So that is the case law which is given here. Okay. Next, example number 22. Similar one. P, a customer in D's shop, puts down a brooch worn on her coat. Okay, what do you mean by the brooch? இங்க கோட்ல வந்து ஒரு ஒரு சின்னதா ஒரு ஒரு ஆர்னமெண்ட் பீஸ் மாதிரி ஒன்று போடுவாங்க, அதுதான் brooch. Okay, own honor coat and forgets to pick it up, and one of the D's assistant finds it and puts it in the drawer over the weekend. யாருமா எடுத்து கண்டுபிடிச்சு drawல போட்டது? D ஓட assistant, maybe some worker in D's shop. Puts it where? Puts it in the drawer on the weekend. On Monday morning, it was discovered to be missing. Mr. D was held to be liable since he was not taking good care of the particular brooch as that of a owner. Sir, அது என்னோட பொருளா இருந்தா நான் எவ்வளோ கேர்ஃபுல்லா வச்சிருப்பேனோ அவ்வளோ கேர்ஃபுல்லா அதை வச்சிருக்கணும். See, it is given it is a brooch, which means it is a very costly ornament. Now, any such ornament, will you just like that leave it in the drawer, or you will put it in a safe place with the locker? You will put it in a safe place with the locker. ஏன்னா உங்களோட பொருளா இருந்தா அதை அப்படித்தானே பாதுகாத்து வச்சிருப்பீங்க. அப்போ இன்னொருத்தரோட பொருளா இருந்தாலும் நீங்க அப்படிதான் பண்ணிருக்கணும். அப்படி பண்ணல அப்படின்னா you are under mistake, you will be liable under the law. Clear? Understood? Yes, I'll give you 2 minutes time. Please go through this one and this one. Please go through.
In the example, why is D's assistant not very liable?
Now, who finds it? D's assistant is finds it. D's assistant only. D's assistant only should be liable. He is the finder of the goods. அதுதான் அவங்க கேக்குறாங்க டவுட்டா. D's assistant was to be held liable. படிக்கலாம். H picked up a diamond on the floor of F's shop and handed over the same to F a manager to keep it until the owner was found. In spite of the best efforts, what is it given here? In spite of the best efforts. அப்படின்னா என்ன அர்த்தம்னா, நான் என்னோட பொருளா இருந்தா அது எவ்வளவு சேஃபா வச்சிருப்பேனோ அவ்வளவு எஃபர்ட் தான் நான் இதுக்கும் போட்டிருக்கேன். ஓகேயா? The true owner could not be traced, and after long try, after the lapse of some weeks, H tendered to F for the lawful expenses incurred by him and requested to return the diamond to him. F refused to do so, held that F, who is the manager, must return the diamond to the assistant or the worker, as he is entitled to retain the goods found against everybody except the true owner. Now, here I have a point of difference, which means this lawful expense cannot be taken from this manager. இங்க என்ன நடக்குது அப்படின்னா, H தானே. Say, Hari picked up the diamond. Hari picked the diamond, handed over to Faisal. Okay, he is the manager. Okay, now Hari has spent, say, 5,000 rupees to search for the owner, and after spending so much amount, say 5 or 6 months went by, owner could not be found. Hari went to Faisal and asked for this particular watch. Now law says Faisal cannot retain it. Hari only should get back the particular watch. In the 5,000 enna madam, can I ask from Faisal? No, 5,000 spent is 5,000 spent. You can recover this 5,000 only from the owner of the goods, and from nobody else. Mr. Hari has all the rights to have it in his hand, because law says the finder of the goods can have the right against the entire world except for the owner. Abdina owner kitta mattumna he is bound to give it back. Whoever comes and asks, he need not give the particular item. அது மேனேஜரா இருந்தாலும் சரி, யாரா இருந்தாலும் சரி, he need not give the item. அப்ப இந்த இடத்துல when Faisal says no, I will not give அப்படின்னா, you can take him to the court of law and Faisal should give the particular item to the finder of the goods. Able to understand? Clear? Yes. Next one. No, we cannot recover the expense. If you want to recover, you can recover only from the owner. Owner கண்டுபிடிக்க முடியல, 5,000 gone. அவ்வளவுதான். Next one, money paid by mistake or under coercion. Now, any kind of money that you paid by mistake, இதெல்லாம் நிறைய டைம் ஆகும். You would have want to GPay, last ஒரு digit மாத்தி போட்டிருப்பீங்க, ஒரு ஜீரோக்கு பதிலா 2 ஜீரோ போட்டிருப்பீங்க. Now it is a clear case of money being transferred to another person by mistake. Now is that another person should enjoy the benefit or I should give back the money? He should give back the money to you. He cannot retain it. He should not enjoy the money. He should repay it. If he is not repaying, now what you can do? You can go to the court of law and file a case to receive back the goods. Same is the case if you have sent money through coercion. You have the right to get back your money. Able to understand? Yes. Let us go see this, or let us read. A person to whom money has been paid or anything delivered by mistake or under coercion must repay or return it. Every kind of payment of money or delivery of goods for every type of mistake is recoverable. You should be able to get back. Sir, என் வீட்ல டெலிவரி பண்ண வேண்டிய பார்சல் பக்கத்து வீட்டுக்கு கொடுத்துட்டாங்க. They cannot enjoy it. They have to give it back to me. Okay. Next one. See the example which is given here. Start reading. A payment of municipal tax made under mistaken belief or because of misunderstanding of the terms of the lease can be recovered from the municipal authorities. The law was affirmed by the Supreme Court in case of a sales tax officer. Now, what actually happened here is, say the rate of tax, actual rate of tax is 5%. Okay. And you are about to calculate whatever sales you made. Say you made a sales of 10 lakh rupees and on that 5% will be say 5,000 rupees. Now this amount should be paid to whom? Paid to whom? Sales tax. Now when you calculate, instead of 5%, you have put 15%. Mistake, by mistake 5% போடும்போது calculate பண்ற இடத்துல you put 15 and calculated 15% and you made the payment to sales tax officer. Now நீங்க பேமெண்ட் பண்ணிட்டீங்களேன்னு சொல்லிட்டு should the sales tax officer enjoy the extra tax? No, he should repay it. He should repay it or refund it because it was a erroneous payment of tax. Understood clearly? Next one, start reading. Similarly, any money paid by coercion is also recoverable. The word coercion is not necessarily governed by section 15 of the act. The word is interpreted to mean and include oppression, extortion and such other means. Oppression means stopping someone from not doing anything. Extortion means kind of mental torture, physical torture. Okay, so இவ்வளவும் எழுதணுமா அவசியம் கிடையாது. I want you to write this alone. This alone if you write, more than sufficient. Seriya? Next one, in case of where Mr. T was traveling without a ticket in a tram car and on checking he was asked to pay 5 rupees as penalty to compound a transaction. Compound a transaction means to set it right. Okay, how will you set right a wrong thing? Either you will be punished and go to jail or you will be asked to pay a fine and penalty. When you pay a fine and penalty, it is called as compoundable offense. When you are the only option is to send to a jail, then that kind of offense is called as non-compoundable offense. Now, in this case, Mr. T filed a suit against the corporation for recovery on the ground that it was extorted from him. The suit was decreed in his favor. Extorted means he was extremely put under pressure and torture. எல்லாரும் எதற்கும் அசிங்கப்படுத்தி என்ன ரொம்ப அவமானப்படுத்தி என்ன டார்ச்சர் பண்ணி 5 ரூபா வாங்கியிருக்காங்க சார். சார், even though it is a penalty, even though you should be able to receive it, you cannot torture someone to receive the money. Able to understand? 5 ரூபா அவர் பே பண்ண வேண்டிய பெனால்டி தான் கரெக்ட், பட் you cannot torture that and receive it. If you are torturing it, then it is a money received under coercion. Under that you are supposed to, now you can take that other person to the law and you can recover the money. Able to understand? Clear? In the above cases, the contractual liability arose without any agreement between the parties. So all these are examples of quasi contracts, meaning there is no actual contract but it is imposed by law. What are the types? What are the deemed cases under which we can see quasi contracts? First one, incapable party. Second one, interested party. Aprom, Obligation of a person enjoying the benefits of non-gracious activity, responsibility of finder of goods, money paid by mistake or under coercion. Okay. Lastly, difference between quasi-contract and a normal contract. Please read. With this, we will break for today's class. Today, your complete work. See, I am leaving you early because I have done completed with one unit. Okay, next class I will start with the new unit. I am leaving you early because next 1 hour I want you to sit with this topic and complete this topic. புரியுதா நான் சார்ட் தரேன்னு சொன்னதுக்காக அந்த ஏரியாவை நீ ஸ்கிப் பண்ணணும்ன்ற அவசியம் கிடையாது. யூ கேன் ரீட் த டாபிக் ஃபார் ஈஸி அண்டர்ஸ்டாண்டிங் அண்ட் ஈஸி replication in your exam. I will give you a chart in the next class. It doesn't mean that you will not read. You will still read it. Clear? Understood? Yes. Once you are done with this difference between quasi-contract and normal contracts, we can break for the day. Yes. என்னப்பா? கிளம்பு. But after coming from college, please do this chapter. Essential for the valid contract. In case of a quasi-contract, what is the most essential item now? So, actually, for formation of a quasi-contract, there is nothing a contract in itself. Contract kadayadu, contract iruknundra avasiyam kadayadu. But for a normal contract, all 11 essentials should be there. 11 essentials nama padichom, nyabam iruka? All of this will appear in case of a normal contract. But quasi-contract ku அந்த மாதிரி 11 essentials இருக்கணும்ன்ற அவசியம் கிடையாது. Obligation, it is imposed by law and it is created by two or more parties out of their own will. Okay, so that is the difference between quasi-contracts and normal contracts. Okay, now this area is a very critical area. Every exam you will find one question from quasi-contract or from contingent contract. Or exam quasi-contract vandaduna innor exam ku contingent அந்த மாதிரி வரும். Okay, ஏன் அப்படினா இந்த area is kind of a area where, to be very fact, இவ்வளோ டீடைல்டா எல்லாரும் படிப்பாங்கன்னு நம்ம சொல்ல முடியாது. Okay, but I want you to do this. Only reason people would skip is it is very confusing அப்படின்றனால they'll skip it. But I believe you should not have so many confusions because we have seen every single word in detail. Still, if you have any doubts, we will take it up in the next class. I want you to come with doubts. படிச்சாதான் டவுட் வரும். வீட்டுக்கு போயிட்டு ஒரு வாட்டி ஒரு தரவு ரீடிங் கொடுங்க. உங்களுக்கு கன்ஃபியூஷன் வந்தது அப்படின்னா எனக்கு தெரிஞ்சு உங்களுக்கு இந்த ஏரியால தான் வரணும். ஓகேவா? இந்த ஏரியால தான் வரணும். இத எனக்காக வீட்டுக்கு போய் 2 வாட்டி ரீட் பண்ணு, தரவா ரீட் பண்ணு. நான் சொன்ன எக்ஸாம்பிள்ஸை மைண்ட்ல வச்சுட்டு ரீட் பண்ணிட்டு come back in the next class. I will also come with the chart. Your doubts will be solved. Okay? Yes, thank you. Bye. Yes. Yeah.
So I went to the question.
Can you just send a snap of it? I'll go home and see. Okay. And I hope previous class you asked one doubt. You remember? And the lunatic or the I just held it there because I wanted to take it in this area so that everyone will know. Okay. Yes, thank you. Bye. Please send a snap of it. Okay.
Sure. Thank you.
Yes, ma'am. ஒரே நிமிஷம்